Okay, we're going to talk limited liability companies for the Illinois bar. Okay, so a limited liability company has, of course, the advantage of limited liability and no double taxation, which is why we love the LLC. But let's talk first about how an LLC is created. So the formation of an LLC is created by state law, and articles of organization are filed, not articles of incorporation, articles of organization, or this is sometimes called a certificate of formation. So what does it need? Similar to a corporation, the LLC's name, the address of the LLC's registered office, and the organizer's name and address. Okay, so just like corporations have bylaws, LLCs have operating agreements. So they are more flexible than corporate bylaws, but they have 5 things in common, and we're going to talk about these. 1, provision for capital contributions. 2, allocation of profits and losses. 3, process for distributions. 4, designation of management. 5, steps for dissolution. All right, number 1 is a list of capital, that's right, contributions. Number 2, allocation of what? Profits and losses. Number 3, how are, that's right, distributions distributed. 4, the LLC's management, that's right. And 5, that's right, steps for dissolution and winding up. Let's go over these things in more detail. So our operating agreement, number 1, list of capital contributions each member has made to the LLC. And of course, there is a requirement, just like a partnership, that that the LLC's managers maintain a separate capital account. Allocation of profits and losses. How are profits and losses going to be allocated? The process by which a distribution may or must be made. Designation of management, and the steps that have to be taken to dissolve or wind up the LLC, and allocation of assets before an LLC terminates. Okay, so we've got our articles of organization. We need 3 things. What are they? Name, address of the LLC's registered office, and the organizer's name, not the incorporator's name, the organizer's name. And instead of articles of incorporation, they are called, that's right, articles of organization or certificate of formation. That's right. Okay, and then instead of bylaws, we have our, that's right, operating agreements, which are 5 points. Number 1, capital contributions and separate capital accounts. Number 2, allocation of profits and losses. Number 3 governs, that's right, distributions and how they're made. Number 4 governs designation of management. Number 5 governs, that's right, dissolution and winding up. Okay, so just as with a corporation, with an LLC, most courts are going to recognize a deficient filing. So they will recognize a de facto LLC and a LLC by estoppel. Okay, so a de facto LLC, if you remember regarding a de facto corporation, a de facto corporation is one that has some sort of deficient filing, but it is still, the court is still treating it as if a corporation was formed. So it obtains quasi-legal status if everyone involved proceeded in good faith under a valid statute for an authorized purpose, and they executed and authorized articles of incorporation. So de facto corporation. Okay, so the de facto LLC, what would that do? It protects the members and the managers of the LLC from being personally sued. So de facto corporation, de facto LLC, who is that protecting? It's protecting the LLC. If in good faith, all, but maybe not all, of the formation requirements were met, the LLC may still be held to exist and its members not liable then for actions of third parties like creditors. Let's contrast this with a corporation or an LLC by estoppel. Okay, so the corporation the corporation by estoppel doctrine provides that if a third party contracts with an entity and honestly believes it was a corporation, they are estopped from denying that the entity was incorporated. Okay, so who does this protect? People who sign contracts, and we're talking people in the corporation and outside of the corporation, who sign contracts on behalf of corporation, but there's a mistake. There's not a corporation, there's a deficient filing. So it's going to protect those people from personal liability. Remember, the de facto LLC or the de facto corporation protects the members of the LLC from personal liability. Whereas a corporation by estoppel, any third party who contracts with an entity that believes it was a corporation is estopped from denying that that is a corporation. So any contract or course of dealing will protect people from personal liability who sign contracts on behalf of that LLC. And those contracts, but for a mistake, they're inconsistent. So corporation by estoppel, LLC by estoppel, same thing. Okay, so beautiful thing about an LLC, remember, no personal liability. Let's talk about member managed and manager managed LLCs. LLCs are very flexible, but typically they have one of two structures: the member managed LLC, where the owners manage the LLC, and manager managed LLCs. So the LLC hires someone to manage it, and the other people are merely investors. Okay, so who has fiduciary duties? The managers in a manager managed LLCs or in a member managed LLC, the people in management have the fiduciary duties. They have the duty of loyalty. So going back to the duty of loyalty, that is, it prohibits self-dealing. Transactions between a member and an officer and the LLC that reduce in unfair secret profits. Usurping an opportunity that rightfully belongs to the LLC for personal gain. Acting in competition with the LLC. And failure to disclose conflicts of interest. And additionally, the duty of loyalty, remember, means remember, when we think of the duty of loyalty, we think of secret profits. So accounting and holding in trust for the LLC. Benefits, money that's derived from conducting the LLC's business. The duty of care also applies to the managers of an LLC. So remember, the duty of care is just the duty of due care, requiring that a person act with due care with respect to their organizational responsibilities. Okay, so then let's talk about a couple things that also apply to LLCs. All right, so promoters and pre-organization contracts. So before you can form a corporation, including an LLC, someone is going to be promoting that corporation. So that could be a single person. It could be an investor looking to raise capital from other investors, any number of scenarios. But before the LLC is formed, those individuals are promoters. Any contracts they engage in are pre-organization contracts. Are those people personally liable on the contract, those promoters? Yes, they are. They are personally liable. Of course, they can contract out of that liability. Okay, what about piercing the LLC veil? Well, that can be done. So piercing the corporate veil, the plaintiffs in a derivative action can sue the LLC's owner managers personally to recover companies' debts in and some injury to the LLC. And when do we have an LLC which is in danger of liability being pierced? When the corporation or the LLC is the owner's alter ego. So remember our two prongs. There's a unity of interest in ownership, and then there's some sort of sanction fraud or promote injustice. So those are our two prongs. So unity of interest in ownership. The corporation, the LLC, is the owner's alter ego. They completely dominate it. They don't observe all the corporate formalities. They commingle funds. All of that stuff gives us unity of interest in ownership, prong one. Prong two, sanction fraud, promote injustice. So if the LLC is used for fraud, fraudulently, wrongfully, or for some sort of unjust act, even incurring a liability it can't pay, breach of contract, recklessness, that's a case-by-case basis. Okay, so just like a corporation, the LLC veil can be pierced. Remember our two prongs, which are what? That's right, unity of interest in ownership. And number two, that's right, sanction fraud or promote injustice. Okay, so an LLC can also be subject to direct and derivative lawsuits. So remember, direct lawsuit is when shareholders, but in this case it would be members, bring an action stating that they themselves have been harmed by the LLC's actions. A derivative lawsuit is brought by the members alleging that the LLC has been harmed. Okay, so those are our similarities to corporations. All right, so what about disassociation from an LLC? Well, that's easy. All you need to do is provide notice. That's it, notice. A member can disassociate from the LLC at any time by providing notice to the LLC. So the moment you disassociate from an LLC, that member relinquishes the right to participate in management. However, they may be entitled to an accounting to determine how much money is owed to them, distributions, and existing liabilities are not necessarily discharged. Okay, so just remember, notice at any time. The disassociating members' interests and liabilities aren't necessarily discharged. That member might be entitled to a distribution. And finally, disassociation of an LLC member, that doesn't trigger dissolution of the LLC. But let's talk about what does trigger dissolution. Okay, so we've got 5 things here. Number 1, the operating agreement provides for the dissolution. Number 2, unanimous consent of all members. This is important. An LLC may be dissolved on unanimous consent of all members. Number 3, the LLC goes 90 days with no members. Now, when could that happen? You create a shell LLC, right? Or everybody quits. 90 days with no members will trigger dissolution. Administrative dissolution by the Secretary of State, when the LLC has probably failed to file something, severely deficient filings, etc., or legal action brought by a member. So direct harm, oppressive conduct. Remember, LLCs are frequently close corporations, so the oppression doctrine applies. It's no longer practicable economically from a business perspective to carry on the LLC's business. All right, so quick review. Okay, do we recognize a de facto LLC? Yes. Who does that protect? That's right. It protects the members from being personally sued for a slightly deficient filing. The LLC's operating agreement usually contains what 5 things? Provides for, number 1, capital contributions and accounting for the capital contributions. Number 2, profits and losses, allocation of profits and losses. 3, distributions, provides for how distributions may be made or must be made. Number 4, management, Number 5, dissolution and winding up. Okay, so our fiduciary duties of loyalty and care apply. Disassociation, what do we need? That's right, just notice. But how can an LLC be dissolved by the state? Okay, so the operating agreement can specify that. How many people do we need to dissolve an LLC? Everybody. Everybody. We need a unanimous vote of all the members to dissolve an LLC. Or 90 consecutive days when the LLC has no members, administrative dissolution by the Secretary of State, or we have legal actions brought by the members. Remember, we have our direct and derivative actions. Okay, so because an LLC is usually a close corporation, what doctrine applies? The oppression doctrine, that's right. So members have acted in an oppressive manner to another member of the LLC that would violate their reasonable business expectations. Okay, and that's our lecture on LLCs. Enjoy.